was absolutely gobsmacking to see these two people openly lie for someone they met on YouTube. Hello, thanks for clicking on this video from Checkmate Humanity. I promise I will try to get through one video without putting my hair behind my ears or futzing with it, but I can't guarantee anything. On this channel, I try to bring awareness and commentary about the inhumanity of social media and how to cope with it. Please hit the like button, subscribe, get your notifications set to all, and then you'll be among the first to know when I post a new video. And please know that this video is for news and entertainment purposes only. Everything contained in this video is my opinion and should be taken as such. Today I'm covering a somewhat chaotic and unnerving case between two YouTubers who went to court in Colorado last week to battle with each other about whether a permanent protection order should be placed on the defendant. The temporary protection order, everyone take a shot every time I go like this. Just kidding. The temporary protection order was awarded to the plaintiff and served to the defendant in January, and on March 7th, they faced off in court for 4 hours. You heard me, 4 hours. And that was just for a protection order hearing to figure out whether to grant a permanent protection order. I'm not going to give the names of the parties in this case because I'm much more interested in what we can learn about it and the implications for social media and online harassment moving forward. For a variety of reasons, I'm also not going to comment on the merits of either party's case. I will, however, convey how the judge characterized the merits of each party's case, and I'll provide a couple links in the description below where you can actually hear the entire hearing for yourself, hear the entire battle. If you do watch those videos, though, bear in mind that the channel that streamed the content is strongly on the side of the plaintiff, so the commentary on that channel comes from that bias. For the sake of this channel, I'm analyzing the case from the context of what I learned in following it, how I see social media's role, and what it could mean for similar YouTuber versus YouTuber cases moving forward. Just to avoid burying the lead, I'm going to give you my overarching opinion about the situation, and it's this. It should never have gotten this far, and social media had a major role in allowing it to happen. But before I get into my observations, it's important to lay a foundation using the facts of the case so you understand how and why it ended up in a courtroom on March 7th. So here are the foundational facts of the case. On January 17th, the plaintiff served a temporary protection order on the defendant while the defendant was live. The two parties have never met in real life and in fact live in two completely different states, hundreds of miles away from each other. What that means is that everything in this case took place on social media, mostly YouTube, but also Facebook and Patreon. In her temporary protection order and application, the plaintiff claimed that the defendant admitted to stalking her for over a year. She said that the defendant obtained personal information about her and used a photo of her husband, who's private and not part of YouTube at all, in a YouTube video well before she ever interacted with the defendant. The plaintiff said that the defendant became fixated on her over the course of a year. She also said that the defendant had threatened to release personal medical information about her and had told multiple people that she was planning to travel to her state. The plaintiff also claimed that the defendant drove to a tire store and impersonated the plaintiff's close friend to get personal contact information about him. Because of all of this, the plaintiff felt compelled to show a picture of the defendant to her minor daughter to tell her not to open the door if she saw the defendant. There was a hearing set for a permanent protection order on January 24th in the plaintiff's state, but the hearing was continued because the plaintiff's lawyers said that more evidence and information had come to light and they wanted more time to prepare. So the hearing was continued until March 7th, which was last Monday. Between the time of January 17th, when the order was served, and the March 17th hearing, the defendant engaged in what the judge called a severe escalation of the harassment. So here's what the judge was referring to. Almost immediately after she was served the temporary protection order, which put in an injunction for her not to continue the behavior that she was displaying online, the defendant hosted multiple lengthy live streams talking about the case and the plaintiff in very threatening terms. In one live, the defendant talks about preparing to travel for the hearing. And at this point, the camera's off when she's starting to talk about traveling. But she then turns on the camera, holds up a Nerf machine gun, shoots it, and says, "Just practicing my aim." In another live, the defendant hosts a mock trial.
He did not go in the store, he didn't steal the candy bar, and he was never even there.
Where she pretends to cross-examine the plaintiff on the stand. In this lengthy live, the defendant openly admits to extending the length of her lives to cost the plaintiff more money in legal fees. The defendant also discusses in various lives that she is going to subpoena the plaintiff's medical records as well as her husband and her minor child. In a later live stream, she talks about how the plaintiff filed a motion to quash the subpoena for her minor daughter, and the quash was immediately granted. What this means is that the subpoena was no longer valid and should not be served. However, the night before the March 7th hearing, when the defendant had traveled to the plaintiff's state to attend the hearing, the defendant compelled two of her friends, who she met on YouTube, to drive to the plaintiff's house with an intent to serve both subpoenas, even though the subpoena for her minor daughter was quashed. And, fun fact, spouses cannot be compelled to testify against each other, so neither subpoena was valid. It was also not being served in a timely manner. It was supposed to have been served for at least 48 hours before the hearing. Yet, this defendant YouTuber got two friends who she met on YouTube to break the court order and attempt to serve the subpoenas. Even if the subpoenas were valid, the defendant's friends didn't even do a proper service of the papers. They pasted the invalid subpoenas on the door of the plaintiff's house. The plaintiff and her family were home at the time, justifiably freaked out, and took photos of the entire incident, including the two subpoenas on the door. Now, one of these witnesses, one of these friends of the YouTuber had actually flown in from Iowa just to do, or I don't know if she flew in or if she drove in or not, but she came in from Iowa just to be part of this proceeding and was roped into this. Now, before I go on with the facts of the case, I want to pause right here and take notice of what I just said. The defendant, who's being accused of stalking, compelled two of her YouTube fans to break the law for her, basically. Break court orders. And I'm being completely serious about that. Because of this situation, all in and of itself, the defendant's YouTube fans are implicated in a criminal action that was compelled by the defendant, a YouTuber. Now, moving on with the facts, as a result of this incident, when all the parties arrived in court, the plaintiff's lawyer requested that the defendant's YouTube fans, who were in the gallery at the time, be sequestered in the courtroom, or at least on the court grounds, and called as witnesses for the plaintiff. So again, think about this. Two YouTube fans who thought they were just there to support their favorite YouTuber are now being compelled to testify against her because of something she asked them to do, knowing it was against court orders. The hearing itself began at 9 a.m. that morning and was scheduled to take place for 1 hour. The parties didn't leave the court until something like 4:30 that afternoon. So they were all at the courthouse for over 7 hours, but since the judge had other cases on her docket, they took a few breaks plus a lunch, and the judge heard other 15-minute cases on her docket, 15 or whatever cases on her docket, while everyone else was on a break. So in totality, the audio transcript from the court is over 4 hours. And in all honesty, it was among the most real 4-hour court hearings I've ever witnessed in my entire life. And I come from true crime community where it's very common to watch hours and hours of court proceedings in criminal cases. So let me tell you why it was so surreal. Probably the thing that most contributed to the surrealness of the hearing is that the defendant represented herself. I've not seen very many proceedings where a defendant represents themselves. One of the most notorious examples of that is when Ted Bundy, a serial rapist and murderer, represented himself after firing his attorneys. The difference between Ted Bundy and the defendant in this case is that Ted Bundy had a legal education. He never got his law degree or law license, but he did go to law school. And he also had a Texas-sized ego, and he was super duper smart. So he felt he was a better representative for his legal case than his licensed attorneys. In this case, one of the defendant's claims to fame on YouTube is that because of her amazing investigative skills and as said by her, and legal knowledge, she was able to retain a lawyer for Chris Watts' attempt to apply for a 35C post-conviction relief. Now, as a reminder, Chris Watts pled guilty for murdering his pregnant wife and toddler children. The man murdered his family, buried his wife and unborn child in a shallow grave with a t-shirt and a thong. And trigger warning for some of the upcoming things I'm about to say. He buried his wife and child, unborn child, in a shallow grave with a t-shirt and thong underwear on, and stuffed his toddler girls, Bella and Cece, into oil tanks on a site where he worked for Anadarko. In order to finance this 35C petition, the defendant stood up a new organization, which she calls a nonprofit, and endeavored to raise $200,000 to obtain the lawyers for the 35C. Since that nonprofit was launched, the defendant has represented herself as a private investigator with significant understanding of how criminal cases work. And under that guise, she has inserted herself into the defense teams of several accused murderers. In each case, the defendant claims that the accused murderer is innocent and uses her YouTube channel to present information that could cause reasonable doubt or a mistrial. I believe that that's what her intention is. With the Chris Watts case, she also famously hosted a mock trial.
So he could not have been in the store. There's only one just verdict in this case. Not, I repeat, not guilty.
Over the course of couple weeks, I think, where she questioned witnesses and sculpted the trials to illustrate her personal theories of the case based on the discovery. In doing all of this, the nonprofit for accused murderers, poring over the discovery, calling herself a private investigator, and holding mock trials, the defendant represented herself as someone with extensive knowledge and understanding of the legal process, and she's developed a small following of fans who are just as confident as she is in her abilities. So that's what set the stage for the defendant representing herself in her own hearing to defend against a permanent protection order against herself. Now, she was in the real world courtroom now in front of a real judge, and I don't think I'm speaking out of turn by saying it was a whole shit show. Just put it this way. During her cross-examination of the plaintiff's lawyer successfully objected 41 times versus being overruled just 15 times. In fact, the judge openly told her that this defendant, that she incriminated herself with her cross-examination and testimony several times. This was so surreal. This woman, the defendant, LARPed her way, in my opinion, from YouTube to the courtroom, believing that the LARPing she did on YouTube, and if you don't know what LARPing is, go see my video a couple videos ago, believing that the LARPing she did on YouTube would work just fine in the courtroom, and really she failed miserably. I know that sounds harsh, but you can go listen for yourself and tell me what you think, and let me know if you think I'm being dramatic. At various points during the hearing, the judge, she didn't want a circus in her courtroom. She had to remind the defendant to stay on track multiple times, and she openly expressed her impatience with the defendant's line of questioning and lack of preparation. And here's another really, really surreal piece of this case. I believe it's unheard of for a judge to sit for 4 hours and squeeze in all her other cases in between to preside over a hearing about a permanent protection order. In most jurisdictions, these kinds of hearings are scheduled for no more than 15 minutes and go by blindingly fast. In some jurisdictions, like the one for this case, the hearing is set for an hour, and that seems like a generous amount of time. But this hearing lasted 4 hours and seemed more like a trial than a hearing. It included testimony and exhibits and closing arguments, and it also included witnesses. Now, one thing that contributed very heavily to the length of time was the defendant's misunderstanding of process and protocol and her lack of preparation. She took exorbitant amounts of time looking through binders for exhibits. Many of the exhibits were totally irrelevant. Only one was admitted into evidence. And the judge had to play a heavy role in guiding her and reminding her to stay on track with relevant information and questioning. The other surreal thing was the testimony of the two witnesses. And these were the friends of the YouTuber. They were each brought in separately, and each had completely or widely differing stories about the facts of what they were asked to do and how they were asked to do it. There's multiple contradictions that are just honestly not worth going into, but the second witness was honestly hostile. She came into the courtroom already with her hackles off. She had left the premises. The court clerk couldn't find her at first, and she was ordered not to leave the premises. When she came back into the courtroom to be a witness, she told the judge that she had called her lawyer and she shouldn't have to be a witness. And the lawyer's like, no, step right on up here. You're doing it. And during her entire testimony, she was defensive and cranky. But regardless of all that, what matters to me is that after hearing their testimony, it was clear that these women were lying for their favorite YouTuber. It was absolutely gobsmacking to see these two people openly lie for someone they met on YouTube. During the trial, the defendant was given multiple opportunities to accept a 1-year protection order, but she declined to do so, knowing that if the judge finds against her, she will be permanently affected in a big way. And that's exactly what happened. A permanent protection order is a very big deal. It's a permanent part of your record. It bars you from holding certain lines of work, like working with minors. The defendant previously coached a girls' basketball team, and she'll never be able to do that again. She won't be able to coach her son's little league. She also, this minor son that she has, it could affect her custody with him. And it's unclear to me at this moment, but I believe that she is also barred from owning a firearm. And she's openly and frequently voiced that she does hold a firearm for her protection. So it's possible she won't be able to do that anymore. Now, the defendant has indicated that she plans to appeal, and that may happen. But in all honesty, she's facing something even more ominous than a possible appeal. Because of her actions, which constitutes contempt of court, she may be facing criminal charges. And we know that the charges are being pressed by the plaintiff because her lawyer said so in court. So all of the parties are also subject to a gag order. But do you think that stopped the defendant from talking about this? Well, it hasn't. She's still talking about it on her YouTube channel. And in my view, every time she does, she's in contempt of the protection order and is subject to more criminal charges. For me, this is where social media comes in. Well, it factors into this entire situation, frankly, but I believe that one of the most unbelievable things about social media is that someone could be ordered to stay away from another person and would get in significant trouble if she violated the order in the physical world. But on social media, she's still given all the tools and methods with which to continue stalking and harassing people using YouTube and social media. She's still actively engaging in the behavior right on YouTube with no fear of consequences to her channel. Since I've been following this case from the beginning, I can also tell you that the plaintiff is far from the first person to complain about the defendant or to feel harassed, intimidated, and stalked. In fact, multiple people have been raising the alarm bells about this incredibly destructive behavior of this defendant, but YouTube still allows her to have a channel. So let me give you a breakdown where I believe social media had a heavy hand in this whole mess. And the first point is by far the most important overarching point. And that is that it should have never come to this. As I was just saying, there's about a year's worth of very loud complaining about the defendant's behavior on YouTube. She's been reported multiple times, and YouTube has never, to my knowledge, penalized her for her behavior. But next, because the platforms have allowed it to continue, it's spilled over into the real world court, which expended extraordinary resources in something that should have been an hour slam dunk trial. What a waste of taxpayer dollars. Social media afforded the defendant a fan base that was useful in boosting her confidence and reputation, validate her, and support her in every facet of her court battle, up to and including committing contempt of court. Social media is also affording the defendant free rein to continue her behavior. It's possible that she'll continue it until she's arrested or sustains some other more severe consequences, or before somebody is really, really hurt in a physical way. People are already hurt, but I mean physically damaged. Since she's no longer able to mention the plaintiff on social media, and since she still has free rein to continue her behavior, the defendant is turning her attention to other people who have been in her crosshairs. So social media's unwillingness to hold her accountable in all cases will continue to help her multiply her targets. In all honesty, I've probably missed several other ways that social media contributed to this, but I'm honestly overwhelmed with the short list I just gave you. It's extremely disturbing to me that the global power that is social media is able to escape any kind of accountability after playing such a massive role in the situation. There were some pleasant surprises in the court hearing, so I'm going to do these points and then I'll end the video on a positive note. First, even though this judge and probably most judges have extremely limited knowledge of YouTube and social media, this case shows that there's a desire and a hunger in the judiciary to understand it better and to rule fairly in these cases. Second, I personally found it extremely helpful in the understanding of differences between public figures and limited public figures, and how each status affects the outcome of a ruling in a case like this. In this case, the judge determined that both parties are limited public figures, which means that they voluntarily inserted themselves into a controversy to express an opinion. Limited public figures have more court protection or legal protection in these cases than public figures. And I think it's important for as many people as possible to understand this. So I highly recommend listening to the audio of the hearing, which, again, I've linked below, and you can hear how it's all discussed and defined, because they can do it much better than I can. Also, I believe through this case, the judiciary will begin to really understand that it's not valid to say, why don't you just get off of YouTube? Why don't you just not go to that person's channel? The judge seemed to understand and embrace the fact that on social media, the content is chosen for you. And when it involves you in some way, it's just totally unavoidable. One of the biggest pleasant surprises to me was how the judge was able to recognize the involvement and accountability of third parties that do things for their favorite YouTubers, and also the YouTubers' accountability in compelling them to do that. It's very possible that the two witnesses in this case could be implicated criminally for helping the defendant violate the temporary protection order. Watching this hearing made it very clear to me that the judiciary is able to make logical connections between the primary defendant and his or her agents. And fifth and final, it was also rather validating to hear the judge react the same way to the evidence that I had when I saw it happening myself. This judge in particular was horrified by the Nerf gun clip and in the defendant's use of the plaintiff's personal information in her content. And at one point, a video was shown in court of the defendant holding her mock trial against the plaintiff, and it was particularly jarring to hear this clip played, knowing that a real judge, a real appointed judge, was watching a complete mockery of the court take place. All told, YouTube spilled into the real world in a real way and in an extremely impactful way last week. And I think that not only should all subscribers and creators take notice of this, but so should the platforms. They are complicit in this entire situation, and there are ways that they could help prevent these situations from spiraling out of the algorithm straight into a real world setting. I don't need to tell them what to do. They know what to do. They just need to do it. In the words of the wise judge in this, we need to get done, finish up. That's all I have for today, but based on the defendant's actions, I believe there will be more to come. Unfortunately, possibly in the near future, so stay tuned for the next episode of Real Housewives of YouTube. Have a great day.